Hi, everybody. Thank you so much for joining us today for our third Tuesday webinar. We have called this webinar, Don't Leave Money on the Table, the American Rescue Plan Act, Business Provisions and How to Take Advantage of Them. We're really fortunate today to be joined by a partner of ours at Lurie and a couple of tax professionals. So you guys know from being in many of my presentations in the past, I'm always telling you, I'm not a tax professional, and I can't answer that question. Well, today, we're very fortunate, like I said, to have a couple on the line with us. So thank you again for joining. Thank you to everybody who's been joining us for our third Tuesday webinars now for the last 2 years. We've presented on a variety of topics, and I think this is the first time we're kind of doing something like this. So, like I said, really excited. I'm Janelle Stanton, VP of Communications here at myHRcounsel. We're joined by Kevin Bezikoff. He's a partner at Lurie, and Chris, and I'm going to just absolutely butcher your last name, so I'm not going to attempt it. Chris V is also here with us today. Couple of housekeeping items, as always, as we get started here. So we do always record the presentation so that if you want to go back and review it, if you want to share it with somebody else in your office, this presentation will be available, and we will be sending it out in an email in the next day or so, depending on the time it takes for it to get downloaded. So you'll receive that. We'll also send out a copy of the slide deck, so you'll be able to get the slide deck and the HRCI credit code. So for those of you that have a need for HRCI recertification credits, you will receive the code to get your 1 hour of credit, again, after the presentation completion. Another thing I want to point out, and I try to get you guys on board with this, and we are going to still keep sending out our survey. Please fill out that survey and let us know what topics you'd like us to present for the third Tuesday. Sorry if you guys who are always joining me are rolling your eyes at me right now, but I promise you I take those survey responses very seriously, and we want to present content that is relevant to your company, that's helpful, and so sometimes my creativity well can run dry. I can't even take credit for this presentation. This was all Mark's idea, our CEO's idea. So if you have things that you want me to present on, please fill out the survey and let me know. I also always like to hear how you guys feel about me as a presenter, as well as any guest presenters that we have. So please do watch for that survey. I'm going to give a little bit of an overview about myHRcounsel. I know many of you are already clients of ours, but I did notice happily today that many of you are not already subscribers to our service. So I'm not doing a hard sell. I just want to give a quick overview, and then I'm going to turn it over to Kevin to talk about Lurie and their services. So myHRcounsel, we really try to change the way that small, medium-sized businesses get access to attorneys. And so we do HR and employment law assistance. We have attorneys that practice business and corporate law, as well as ERISA. And these are all services that can be accessed based on a subscription fee model that's very reasonable. And it gives you 24/7 access to our attorneys through our Ask an Attorney portal. So like I said, I didn't want to do too much here about myHRcounsel because many of you already know who we are and what we do, but I did want to put in a little bit of information about us for those that may not be familiar. But I'm going to now turn it over to Kevin to chat with you about the services that Lurie has available.
Good morning, everyone. I'm Kevin Bezikoff. I'm a partner at Lurie, and Lurie is a CPA firm. We're an 80-year-old CPA firm with offices in Minneapolis and in Fort Myers. We're a full service CPA firm, so we offer everything from your bookkeeping and accounting up through your audits and tax work that you need. We also have specialty areas in terms of business valuation, litigation support, transaction advisory services, as well as specialty tax related to things like cost segregation studies, R&D studies, and COVID relief. So the picture that you're seeing here represents what we've called our economic relief team. This is a group of professionals that have come together last February, and we put this team together representing people from across our organization. We did it because we believed that there would be a short window of opportunity to help our clients get through the various legislation that was coming out. And this group has quickly digested the legislation that's come out, communicated it to clients and others, and have been available for resources related to everything COVID. So, you know, initially it started out as PPP loans and FFCRA and morphed into employee retention credits and carrybacks and everything else under the sun that has come out in the legislation over the past year and a quarter. So, you know, this team came together. We thought we were on a 2-week assignment, and it ultimately is going to be probably a 2 to 3 year assignment. So we like to call it our own Gilligan's Island. And for those of you who are dying to find out, it is Chris Van Schooneveld, and Chris Van Schooneveld and I co-lead this team. Let's see, now I need to go to the agenda. Oh, there we go. So today we're going to talk about really 3 things that have come out recently related to COVID relief. The employee retention credit, which really had been out since the beginning, but had become a much more usable program as of January of this year. The Restaurant Revitalization Fund, which is of critical importance to restaurants getting back on their feet, and then Section 139 plans. Chris is going to talk about the employee retention credit, and I'm going to turn it over to him.
All right, and I'm going to make you the presenter here, Chris. And one thing I forgot to mention, if you guys have questions, please enter them in the questions box, and I will be kind of monitoring that. So just make sure if you've got pressing questions, go ahead and pop them in there. I'll be monitoring.
Thanks, Janelle, and thanks, Kevin. Good morning or good afternoon, everyone, wherever you're located in the U.S. And I am going to be discussing the employee retention credit. And we decided to start this off with actually a couple scenarios just to illustrate how lucrative this credit can be if you qualify. Once we go through the scenarios, we'll then go into a little more details on the actual credit and how you can determine whether it qualifies and how it's calculated. So in this scenario, Company A finds that they qualify for the employee retention credit in Q2 and Q3 of 2020. They have 40 employees, and they were able to pay all 40 of those employees up to or at least $10,000 in qualifying wages per employee. As a result, based on the 2020 employee retention credit rules, they are then eligible for a $200,000 refundable employee retention credit. In scenario 2, the same company, Company A, they find that they are also eligible for the ERC in Q1 and Q2 of 2021. They still have 40 employees. Based on the rules for the 2021 ERC, they have a total of $10,000 of qualifying wages per employee per quarter, so $20,000 in total for those 2 quarters. And as a result, they are able to get an employee retention credit in 2021 of $560,000. So between these two periods, 2020, the 2020 ERC and the 2021 ERC, Company A is able to get a $760,000 refundable credit for the ERC. So as you can see, this is well worth the effort if you're eligible for the credit. And now backing up to go more into the details, you know, the employee retention credit came out of the CARES Act and was really established by Congress as a means to assist employers in keeping their employees employed. And the first thing to think about is that this isn't an income tax credit. This is an employee, or I'm sorry, this is a payroll tax credit. And it started in 2020, and it really wasn't something that anybody talked about much initially. And the reason for that was up until December of 2020, when the Consolidated Appropriations Act came out, up until that point, you weren't allowed to take advantage of both the ERC and the PPP. You could only do one or the other. And obviously everyone wanted the PPP because assuming you use all the funds correctly during your covered period, you're going to get 100% forgiveness for them. When the Consolidated Appropriations Act came out and went into effect December 27th, that changed. Basically, you then became eligible for not only having the PPP, but also taking advantage of the employee retention tax credit. The one catch is you can't use the same payroll cost for both programs, but you can apply it retroactively. So if you're sitting here now in 2021 and you're thinking, geez, I didn't do anything for this credit, you can go back, even if you've already applied for forgiveness for your PPP, you can go back to 2020 and amend those 941s and claim the credit. Like I said, the key though is you cannot claim the same payroll costs for the ERC as you do for the PPP. And also, actually, it's not just the PPP, it's also FFCRA or the Work Opportunity Credit. Basically, any of the CARES Act programs or other credits, you have to make sure that you're properly allocating the cost between those different items. But obviously the goal really, and the way we look at it with our clients that we're working with on this, is the goal being to get full forgiveness for their PPP and at the same time maximize their ERC credit. So the way the credit works is the first step is identifying what periods you may qualify for. And as I said before, this is a payroll tax credit, so we're really looking at quarters. So in generally what we're looking at, there's actually two ways to qualify. And I said we're looking at quarters, but you actually can qualify for periods that are shorter than a quarter, and I'll explain how in a second here. But there's two ways you can qualify, and you don't need to have both of these situations or both of these factors. You just have to have one or the other. The first way to qualify is either based on a gross receipt reduction of greater than 50% in 2020 or greater than 20% in 2021 in a quarter. And so what that means, so for example, if we're looking at 2020 and we're looking at, say, Q2 and Q3, just like Company A was, we're going to say, do they have a greater than 50% reduction in either or in any of the quarters as compared to the same quarter in 2019? And so if we find that in Q2 of 2020 compared to Q2 of 2019, they actually had a gross receipt reduction of greater than 50%, that then becomes a qualifying quarter. And then the way the rules are written, in 2020, once you have a qualifying quarter, you are then guaranteed that the next quarter is going to qualify as well. The subsequent quarter, so in this case for Company A, the subsequent quarter would be Q4. They can qualify for Q4 as long as the gross receipts in Q2 or Q3 don't go up or don't go up above a certain level. In 2020 or 2021, excuse me, the gross receipts reduction test, you're still looking at quarters in 2021 compared to the same quarter in 2019, but you only need a gross receipt reduction of greater than 20% as compared to 2019. And they actually added a little twist too with 2021. You can look at the current quarter you're in as well as the preceding quarter. And if either of those two quarters has a greater than 20% reduction, you qualify. So for example, if I'm looking to see if I qualify in Q1 of 2021, I'll look to see, did I have a greater than 20% reduction in gross receipts in Q1 2021 as compared to Q1 2019? And if I didn't, I can still look back at Q4 of 2020 compared to Q4 of 2019. And if I had a greater than 20% gross receipt reduction, I then qualify for Q1 of 2021. And it goes like that throughout the year. So each quarter, you're looking at the quarter you're in and the preceding quarter to see if you qualify. The other way that you can qualify, other than gross receipt reductions, is if you were shut down either fully or partially as a result of a government order. And the way this works is, and it has to be a government order. It can't be just a decision to say, we're going to shut down because we want to, protect our employees. While that's, a good thing, or that was a, good to be worrying about your employees. If it wasn't specifically because of a government order, it won't count. But assuming it was a government order, full or partial, your covered period begins on the date that the government order goes into effect, and it ends on the date the government order ends. And so that could be a 2-week period, could be a 1-week period, could be a couple-month period, or could be the entire year of 2020 from March all the way through the end of the year. But the key is that it begins right when the government order goes into effect and ends right when the government order ends. The full shutdown is pretty straightforward, right? If you're a non-essential business, or if you were considered a non-essential business, you were told you can't be open, and that's pretty cut and dry. The partial shutdown is a little more nuanced and takes a little bit more consideration, because you may be a company that has a portion of your business that's considered essential and another portion that's considered non-essential, which was shut down. The way the IRS wrote the rules is that as long as that portion of the business that was shut down makes up more than a nominal portion of your overall business, then you qualify as being partially shut down, and you can claim that as a qualifying period. Once you've identified that you have a qualifying period or a qualifying quarter, all of the qualified wages paid out during that period are then eligible for the employee retention credit. And so in 2020, you would say, okay, if we qualified in Q2 and Q3 of 2020, and we had, like in the example with Company A, we had a total of $10,000 of at least $10,000 of qualifying wages paid out to employees during those 2 quarters. You then can multiply that 10,000 by 50%, and that's your credit. So meaning a $5,000 credit. In 2020, your maximum credit between all the quarters is going to be $5,000 per employee. So even if you had $10,000 paid out to an employee in Q2, $10,000 paid out to that employee in Q3, you're still only going to have a $5,000 credit based off of 10,000 qualifying wages. In 2021, they changed the rules to where the limit is per quarter. So you can have $10,000 of qualifying wages per quarter. And the credit percentage goes up from 50% to 70%. So if you qualify in Q1 of 2021 and Q2 of 2021, you now can take $10,000 of qualifying wages per employee in Q1 and $10,000 per employee in Q2. And each one of those is multiplied by 70%, so $7,000 per quarter, $14,000 in total. When the American Rescue Plan, which just came out in March, went into effect, they extended the 2021 portion of the ERC, which was originally limited to just Q1 and Q2. It extended it to Q3 and Q4 of 2021 as well. So theoretically, if you're a company that qualifies, you could have an employee, and you have enough qualifying wages, you could have an employee that gets $10,000 of qualifying wages per quarter. So we're talking a maximum credit per employee of $28,000. So this could be an extremely lucrative credit in 2021.
Hey, Chris.
Yeah.
We have a good question.
Sure.
So tell me, so the question here is, how does the full or partial shutdown work when the company has several business lines, like an open golf course but limited restaurant service, or a vet with boarding services that are closed?
Yeah, so that's a great question. And yeah, the way the partial shutdown works is, like I said, there's going to be businesses, and the IRS recognizes this, that there's going to be businesses where you have portions that can be open and portions that can be closed. And when you're looking at things from the standpoint of the ERC, you're looking at what's called the aggregation rules for the purposes of credit. And so basically, if all of those are in one company, if all of those different segments are in one company, then it's going to be, as long as the segments that are shut down are greater than a nominal portion of the overall business, which the IRS defined as greater than 10% of gross receipts or greater than 10% of employee work hours, as long as that portion that is shut down makes up more than a nominal portion of that business, then the entire business is considered partially shut down. If those are actually different segments, but they're actually held in different businesses, assuming that the ownership is comparable between the different companies, then they can be aggregated together. And there are some specific nuances that really need to be looked at to make sure. The IRS talks about, parent subsidiary relationship or brother sister organizations. So basically there are some specific factors you have to look at to see if you can aggregate. But assuming you can, then they all get aggregated together and become considered one company for the purposes of the ERC. And so then, as long as that business segment makes up more than a nominal portion of that combined aggregated entity, then the whole aggregated entity qualifies for ERC. So another good example of this is if you have a multiple companies owned by the same owner, and they're located in different states, and obviously different states have had varying rules regarding the shutdown. So let's say maybe you have a company that has 3 locations in Florida and 1 location in California. Obviously extremely different in terms of, California is going to be shut down, Florida is going to be largely be open. If that California location makes up more than a nominal portion of the total combined entity, then the ERC applies to the entire entity, even the 2 locations in Florida that may not have been shut down very much at all. So that's kind of the way it works. But it is a very specific, or it is probably the most subjective portion of the ERC. And if you do find yourself in that situation, I definitely recommend evaluating with your tax advisor on making sure, 1, that you're looking at the aggregation rules properly, and 2, developing a good narrative or a good background explanation of why you find the company to be partially shut down. Because of the amount of money that's going out, we are definitely expecting that the IRS will be auditing these. And of all the different factors, that seems like the partial shutdown consideration is probably the one that the IRS will try to challenge the most, because they'll probably get the most have the most ability to find adjustments in that area.
Thank you so much, Chris. I have more questions. Would you prefer me to hold off till the end, or I can ask them now? It's up to you.
No, that's fine. You can jump in now.
Okay. So one of the questions is, what is the deadline for applying for the 2020 credit?
Yeah, so it's there's actually there's no rush. You should have 3 years to file the amendment. I don't believe that was extended. I know the IRS extended their statute of limitations, which is typically 3 years to do an audit. They extended it to 5 years for the ERC because there's so much money going out. I don't know if that affected the time period for when you can apply, but you should have at least 3 years from the date of your original filing of your 941. So it's not something that you need to be losing sleep over. It's definitely a great opportunity, and obviously people want to get the money as quickly as they can. but you don't need to lose your sleep over thinking that you're going to miss out on this credit if you don't get it filed next week or anything like that.
Awesome. We've got a bunch of questions rolling in, so I'm going to let you finish up, and then maybe before we switch over to Kevin's topic, we can finish up with some of these questions.
Okay, sounds good. So just to go through, this is a nice chart. I like this chart because it goes through kind of how the program has developed and the different iterations of it. Like I said, the program initially came out with the CARES Act, which was enacted March 27th. And the original ERC covered the period of March 13th, 2020 through the end of 2020. That period is still the same. So if we're looking at 2020 ERC, we'll be able to use qualified wages paid out during, assuming you qualify, have a qualifying period. Any wages paid out Q2, Q3, Q4 are eligible. For Q1, it's only eligible for wages from March 13th to the end of the month. This has to do with, they timed it with when things really started impacting us here in the US with the coronavirus. In 2020, there's a size limit of 100 full-time employees. And what this means is that if we look at 2019 as the measurement period for the size of a company, and if in 2019 you had greater than 100 full-time employees, those being people who work 30 hours or more per week, if you had greater than 100 employees, full-time employees, then your qualified wages in 2020 are limited to only those wages that were paid to employees who were not working at the time, so not providing services for the company. Typically, this would be a situation where you're furloughed, or because of gross receipts being so heavily impacted, you had to, shut things down at the business, but you still kept paying employees. And this can either be gross wages paid to employees or company paid health insurance payments. The maximum amount, as we talked about before, is $10,000 of qualifying wages for the entire year of 2020, which at 50% translates into a total max credit per employee of $5,000 per employee. This is refundable. Gets applied to the Social Security tax first, and then any remainder is refunded to you. With the Consolidated Appropriations Act at the end of December, the Q1 through Q2 of 2021 became eligible for the ERC. The wage limit, or the size limit, in 2021, we still look at 2019 average full-time employees, but the limit goes from 100 up to 500 employees. So that means if you have 500 employees or below, all wages paid to employees counts toward, or can be used to for the ERC, assuming you have a qualifying period. Anybody above 500 is then still limited to only wages paid to people not performing services. And similar to 2020, employer paid health insurance can be paid. As we discussed before, in 2021, it changes to where you're no longer capped at 10,000 for the entire year. In terms of qualifying wages, you're capped at 10,000 per quarter. So a grand total of 40,000 in qualifying wages per employee for the entire year of 2021. It's a 70% credit, so $7,000 per quarter, up to a total of 28,000 for 2021. Q1 and Q2, it'll be applied against the Social Security, then refunded. The Q3 through Q4 will be applied against the Medicare portion and then refunded. The last point I want to make is on the American Rescue Plan. That's the plan that came out in March and extended the 2021 ERC to Q3 and Q4. The same rules apply as Q1 and Q2 for most companies. There were two new categories created, though, with the American Rescue Plan. The first is for large employers who are over 500 employees. If they find that in Q3 or Q4 they had a greater than 90% reduction in gross receipts, they then are allowed to claim all wages, not just those, or not only wages paid to employees not working, it then allows them to claim all wages for even those large employers. The second one is the a recovery startup company. This would be a company that started subsequent to February 15th, 2020, so started during the pandemic shutdowns. As long as they didn't have combined gross receipts of greater than 1 million since they started, they are then going to be eligible in Q3 and Q4 to claim up to a total of $50,000 $50,000 credit in both quarters. With that, that covers all my slides, but Janelle, obviously you said we have lots of questions, so if you want to start reading through those, we can.
Okay, awesome. And just, yeah, if there's something that, again, you know, is not really something we can answer because it's too specific, just say that. That's okay. So one of the questions we have, and you may have already touched on this, but what about companies that are under 100 employees?
Yeah, companies that are under 100 employees are eligible to claim it on all wages paid to employees. So even if, you know, so the key differentiation is that if you're a large employer, so over 100, is that the wages have to be paid to people who are not working. If you're 100 or under, then you can claim it on wages for people whether they were working for the company and providing services or not. It doesn't, you know, you can claim all the wages. The one thing you can't claim is you can't claim severance. So if someone was let go and was paid severance, you can't claim that because that kind of goes against the idea of retaining employees for the credit. Janelle, do you think I answered that sufficiently, or do you need me to go into more details on that one?
Oh no, that was perfect.
Okay.
Thank you for that. Another question is, has the IRS released a draft of the Q2 941 form yet?
I am not. Just the plain 941 form?
Yeah, that's the question just asked for the plain 941.
Yeah, I don't know for sure on that. Kevin, do you know if that's come out yet? He might be muted still.
Oh,
there
I was muted here. You know, I don't know.
If we had
sorry to say, I don't know.
If we had Becky Munson from our Your Books group on the call, she would, I'm sure, know. But
we can also look it up too in the meantime, and get back.
There is one on the IRS website. I just don't know if this has changed in any fashion.
Yeah.
That was from March of this year.
Yeah.
Okay. So it seems like maybe not, but yeah, we can. To the person who asked that question, we will research and we'll get you an answer one way or the other on that.
Yeah. The one thing I do want to mention. Can I mention one thing that you know?
Yeah,
so the way we're claiming these credits for 2020 is by filing a 941X, which is an amended 941. And for most people, because many companies received PPP2 dollars, so with the second round of PPP, for most companies like that, our recommendation is that the best way to claim this credit is to wait until your covered period for PPP is ended, which is typically for almost everybody going to be ending, no earlier than Q2 of 2021. So our recommendation is, because of the fact that you have plenty of time to file for these credits, is to wait, especially if you have a PPP loan or PPP2, wait until the covered periods end. Go ahead and file your 941 as usual, and then you can go back and amend through a 941X to claim the credit. Because the last thing you'd want to do is claim the credit on the ERC and then accidentally take some of those payroll dollars that would have been used to get full forgiveness for your PPP and apply them towards the ERC, and then miss out and have to pay money back for the PPP loan.
Awesome. That's thank you for that information. That's awesome. Couple more here, and then we'll get it turned over to Kevin. Are the qualifying ARPA sick and family leave wages paid for Q2 and Q3 of 2021 exempt from the employer Medicare tax for payroll tax calculations? So employers can take the employer Medicare tax credit immediately. Can take that immediately on a per payroll basis for these ARPA wages paid for Q2 and Q3 2021.
So that's actually a question that I don't know if Kevin knows that question, but that's actually outside my area of expertise on this. My area of expertise is on the employee retention tax credit portion, but that being said, we have people in the firm that are experts in that area, and we could, if you want to, we could potentially have them follow up on that question, Janelle. If you want
absolutely.
to provide the contact information, we could try to get an answer for them on that one.
Yeah, so just so you guys, every time that, because people who attend my webinars really love throwing me for a loop. And so every time somebody asks me a question that I'm not sure about, I say, awesome question. I'm going to research that, and I always follow up individually after. So that's not a problem at all.
Okay.
So I've got one more here. Do part-time employees qualify in 2021? And then I think we can move on.
They for the ERC. So
yeah,
just to let everybody, so just to make sure I'm clear and no one's misunderstanding, it is not just wages paid to full-time employees that are eligible for the ERC credit. You can take any wages paid to part-time or full-time employees are eligible for the ERC credit. The only reason we mention full-time employees, those over 30 hours a week, is that is just the testing factor for whether you're a large or small corporation for the purposes of the ERC. So you can claim the credit on wages paid to unqualified wages paid to part-time or full-time employees in both 2020 and 2021.
Perfect. Thanks so much, Chris. So Kevin, I'm going to give you the keyboard and mouse, so you should have the control now.
Okay. Oops. Now, where's the scroll on it? Apologize.
You just have to click on the screen, Kevin.
Oh, okay. I am. It's not switching.
I think you've got it now.
Sorry about that, guys. I'm just not getting this to move.
Let me try it again.
While we're working on the technicalities here, just so really a summary is, when it comes to ERC, there is no bad question. There's no dumb question. There's so many twists and turns and so many ways to qualify that, one of our favorite things to do is to just, spitball it, throw up the scenario and say, based on these quarterly revenues and this payroll and this headcount, do we qualify? And figure out if we do or don't. Oop. And so I'll leave it at that. It's literally going back to the name of this presentation. It is literally free money if you qualify. So no dumb questions, no bad questions. Just best thing is to just talk it through and figure out if there's a qualifying event. So a new program that also came out, COVID relief and ARPA, was what's called the Restaurant Revitalization Fund. This put over $28 billion into a fund administered by the SBA, specifically to provide financial resources to restaurants, bars, food trucks, caterers, etc., to get them back on their feet from the pain and suffering that they had during COVID. Right now on the SBA website, there's an application process that is open specifically to targeted groups right now, and another 3 or 4 days it's opening up to everyone. Pretty simple application actually, and pretty simple in terms of what it looks for. It's really looking for what is your reduction of gross receipts between 2019 and 2020, less PPP funds that you've received, to calculate what a maximum benefit is available to a qualifying organization. Based on that calculation, the maximum amount a restaurant can get with one location is $5 million, and the maximum amount that a multi-location restaurant can get is $10 million. And those funds are used for eligible expenses between now and March 11th of 2023. So what can they use it for? They can use it for payroll, mortgages, rent, utilities, maintenance, building outdoor seating, supplies, operating expenses, food and beverage costs. So really pretty flexible in what it's allowed to be used for. I have submitted a couple of these applications. They are still in the processing phase with the SBA. What will be interesting with this is while there is $28 billion allocated to the fund, in just the couple of weeks that it's been open to specific targeted groups, it is already substantially oversubscribed, and we don't have clarity yet on how the fund will ultimately be dispersed, whether it's going to be chopped up or whether it's going to be more funds added to it is TBD. But if you're a qualifying restaurant, it is another opportunity to get some grants to help you recover. Now, another area of COVID relief that hasn't quite really been as on the forefront as some of the PPP and the retention credits and things like that is something that's actually been around for quite a while now and just sort of reemerged under COVID, and it's qualified disaster relief. Qualified disaster relief is governed under Code Section 139 of the IRS regulations. It's a 2001 law that created a vehicle for companies to pay for disaster relief for their employees on a tax favorable basis. So I always like to start with the basic scenario. So hurricane hits Louisiana or Houston or one of the areas prone to hurricanes. The president declares a disaster, and then people need resources quickly. So when a disaster is declared, disaster relief code section 139 kicks in, and it allows companies to pay for things, deduct them as expenses, and not have them be income to their employees. So hurricane, that runs through, and people need food, water, shelter. Companies step up and they buy some food, they buy some clothing, they house their employees maybe in hotels or whatnot for a period of time. That is considered deductible by the company and not income to the recipient. On March 13th, 2020, President Trump declared a national disaster related to COVID-19. So that kicked in Code Section 139. And what we have really is a very different disaster. So it's not a physical disaster, really not even a temporary disaster. It's a longer term disaster with very different needs by employees. So that being said, though, it was and continues to be a significant disruption to people's lives and significant disruptions to how people work and how people take care of their families. So under a 139 plan, we have a whole bunch of different types of things that people have had to spend money on. Some of you, either yourself or your employees, had to outfit a home office so that you could work and not have a pain in the neck for your work surroundings. Maybe you had medical needs related to COVID for your family. Maybe you had wellness needs related to your family that have been increased costs for you in connection with responding to the pandemic. All those types of things make the case for why a 139 plan would be something that could help employees ease the burden of working from home and doing everything else from home. So we talked about this already, but really a qualified disaster relief plan is an expense that's more like an expense reimbursement than a wage. So it's when you're reimbursing or paying for something for an employee that is necessary for them as a result of the disaster. We put a plan in place in our office and included a number of different expenses. And the expenses that qualify are the things that got more expensive as a result of COVID. So things like working from home. So that office you had to set up if your utilities went up. If you had medical expenses related to COVID, early on, a lot of the testing had to be paid for. Some of the treatments were paid for. All things are includable as types of expenses that would qualify under a 139 plan. Wellness. In terms of wellness, we included both physical and mental wellness related to the stress that working from home and the pandemic caused on people, that maybe caused them to need to speak with a counselor or something of that matter. Are expenses that are legitimately qualifying under a 139 plan. Also, it's not just the employee, but it's also the family that can have additional costs related to the pandemic. And those additional costs can also be included in a 139 plan. So if you had to bring in a more expensive nanny than the daycare that you were sending your children to, that additional expense may be includable in a 139 plan. If your kids were struggling at school from home and needed additional tutoring, that could be included. And other expenses related to your children and students, either working from home or going to and from a place of school. So really what's not included is it's not a plan that is designed to cover compensation. It's different than compensation. It's to recognize and help out related to a disaster that is that required people to spend additional money. So, and it's also not a luxury plan where items that are sort of non-critical would be included. And of course, if something is covered by insurance, it would be excludable as well. So if, let's say now you want to put a 139, you're an employer and you want to put a 139 plan in place, what does it take? Well, technically the IRS doesn't require any form of a formal plan documentation. Um, but it wouldn't be a bad thing to document that you did have put one in place. And really what would be valuable in terms of tracking a 139 plan would be one, having a form so that employees can submit the expenses, whether that be a paper form, an Excel spreadsheet, or if you happen to have an online expense reporting tool, it's a matter of configuring those to allow for the receipt of 139 plan expenses, requiring that the employee provided an affirmative statement, and then just really confirming within that the expense was not reimbursed by insurance. So really it comes down to following a pretty standard expense reporting process. We like to get the receipts, we recommend getting receipts during the course of providing the reimbursement in the event you ever need those. So what have we done? We put together a short set of resources related to a 139 plan. So, you know, 1 or 2 page plan document that basically says why we set up the plan, what's covered, what's not covered, the dollar amount, if there is a dollar amount, an employee communication, which would be, you know, here's the plan, here's what it means to you, here's the dollar limit, here's the time frame to submit expenses, and here's the process to be reimbursed, as well as the expense tracker, which in our instance was a simple Excel spreadsheet that we utilized to collect receipts. Those 3 pieces really encapsulate the necessities of what makes up a 139 plan, how to communicate it and how to execute it. So just to reiterate that again, the 139 plan is a response to a disaster. It exists during the time of a disaster and ends when the disaster is over, and allows companies to reimburse expenses to employees so that they maybe take a little stress out of their lives in terms of what it takes as an employee and as a family to respond to the pandemic.
Awesome, thank you, Kevin, for all of that information. I have a few questions about the plan here. So one, do Section 139 plan expenses need to be universally offered for all employees, or can it be selected for key employees?
Yeah, that's a good question. Since it's not like a ERISA plan or like a 401k qualified plan, it actually can be targeted. It can be targeted by amounts. It can be targeted by who it's offered to. You know, we certainly saw that where there were towards the end of last year, certainly different levels for different employees and different participation based on how much someone was in or out of the office or working from home or not working from home.
Okay, thank you. So I'm already being asked if there's going to be another webinar or if this one's going to be copied. So yes, the answer is we did. We're recording this webinar, so everybody in attendance will be able to get a copy of this recording. We do have a couple of other questions here. One of these is relating to the ERC. So the question is about wages and whether wages paid to shareholders and spouse are something that can be part of that ERC.
Yeah, so the limit on that is if it's an owner of greater than 50% of the company, then wages paid to that owner and their relatives, spouse, children, whatnot, can't be included. So if it's an owner of 50% or below, then it's still okay. But it's just if they're greater than 50%.
Okay, thank you. Lots of ERC questions here, Chris. Lucky you.
Yeah.
Another one here for ERC. If I have 101 full-time employees spread across 21 locations, is that 100 full-time employee limitation for all employees at one location?
So no, it's going to be, it's based on what we talked about before, the aggregation. So if you have 21 locations, they're all in one in one entity, then it's going to be 100. It's going to be looked at as a total, as one entity. If each of these 21 companies are in different, the 21 locations are in different companies, but the ownership is the same throughout all the companies, or they're under one parent company, then it's still going to be looked at as one company in total. So the way the size limit applies to everything. There's no specific limitation like they had in the PPP for certain types of companies like restaurants, where they were able to look at the size limit for each location. That doesn't translate to the ERC. It's basically if they're one company, then you look at the whole, regardless of it being in multiple locations. If they're aggregated because of common ownership, then they're also looked at as one company altogether. You also look at it when you do the aggregation. You also look at the gross receipt test based on the total gross receipts of all the companies that are aggregated together, not separately.
Okay. This is a Section 139 question. So one of them is, how can we receive the resources that were shown for the Section 139 plan, and what are the steps for receiving that credit?
So the first question would be reach out to us or reach out through Janelle, and we can definitely have a conversation about the resources and likely provide them. In terms of the credit, it's really not a credit. So it's not like a government, it's different from the ERC and PPP and things where the government was giving out money. This is more of a opportunity to pay employees, reimburse them for expenses that they incurred on a tax favorable basis. So it's a little different in that it's not something that is going to, it ultimately costs an employer money, but it will ultimately be a benefit for employees and employers.
Perfect. And I'm going to be sending out a follow-up email to everybody, so you'll have our information. If it's something that, if you're interested in any of these resources, you can always reach out to, and I'll put our contact information back here, info@myHRcounsel.com. If you guys want us to get you connected with this awesome team at Lurie for more specific counsel on these tax and other issues, feel free to reach out to us and we'll get you guys connected. And if you'd like to receive those resources on Section 129 or anything that we've talked about today, certainly feel free to reach out. And then, of course, we have Lurie's information here as well. You can reach out directly to them and get more of this wonderful tax counsel. And so we are right up on the hour. I know I wasn't able to get through all of the questions. I assumed that would happen. Anything COVID related has just garnered a lot of questions from you guys. So if we didn't get to you, I'm definitely going to send off this question list to Chris and Kevin and see if they'd be willing to share any more of their expertise to those with us. That would be fabulous. And then otherwise, I just want to say thank you so much for everybody for attending. You guys have been great. These were great questions. I want to thank Kevin and Chris so much for coming and sharing their expertise with you guys. I think this is a very beneficial webinar. So again, look for an email from us with the survey question, with the HRCI credit, the recorded presentation, and a PDF of the slide deck. We'll make sure we get all of that shared with you guys. And as always, thank you so much for joining our third Tuesday webinar series. So Chris and Kevin, thank you. And everybody else, have a great rest of the day.
Thank you.